I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. This is number 188 on our compilation list. Today, we will be featuring two different courtrooms. Before I give you the rundown on those courtrooms, don't forget that commentary will be left in these proceedings if there is any from the previous airing. Also, there will be chapters added for your convenience. Don't forget to like, comment, share, and subscribe. And now let me give you a rundown on the courtrooms that we will be in on today. For our first proceeding, I was not able to find out who this judge from the state of Colorado is, but I do want to shout out Sovereign Citizen Chronicles for sharing this proceeding with me. So it is out of a Colorado courtroom, but I do not know who the judge is. But this man that is before him, Mr. Sullivan, definitely has his sovereign citizen head on. And for our second proceeding, I do know this judge by the name of Judge Kenneth King, and he has a sovereign citizen before him that is very popular on the channel, very popular in the sovereign citizen space. But for this particular case, he does not have his sovereign citizen head on, but it is a very serious case. And I wanted to share with you guys because I think when you see this, his previous proceedings before Judge Perkins, before rest in peace Judge Donna Millhouse, you'll kind of get why he's so aggressive and the way he is, and how also reflects in other areas of his life, because this was a very serious case before Judge King. But I won't tell you who he is. You'll have to wait and see for yourself. And listen, nothing else to be said, but let's go ahead and jump into 188.
Jared Sullivan, 25 M426 24 M439. And good morning. Can you tell me your name, please?
I'm Jared Mark of the family Sullivan.
People, what is the outcome of your conversation, Mr. Sullivan?
Your Honor, Mr. Sullivan indicated to me that these are likely going to become trial cases. I do have a note in the file that Mr. Sullivan filed a discovery demand, but has not yet come to our office or requested that discovery in any way. So I did inform him that he can go upstairs to our office and request that discovery. I also offered to provide the Larimer County website where you can make a discovery request, but he did not want that website written down for him. So I've instructed him up to the second floor to request that discovery after this court date.
Okay. Mr. Sullivan, what are you asking the court to do today?
Well, I'd push for another dismissal based on failure to state a claim.
Your motion to dismiss is settled, and I will no longer be considering any more motions based on the grounds you previously asserted.
Well, and your response to that is just adding claims on the record that haven't been brought up by either parties. And it leaves the appearance that you're acting outside of the bounds of your duties as an independent third party.
You are asking me to review motions and issues that I reviewed, I think, last year and already acted on, and I'm not doing that again.
Do you have an oath to the Constitution on record, sir?
Beg your pardon?
Do you have an oath to the Constitution on record?
We've discussed this, and so we're going to move on. You are choosing to...
Do you have an oath of office on record to the Constitution, sir?
Sir, you may not interrupt me. I'm going to go through... You are choosing to represent yourself, is that correct?
Yep.
Then I have to ask you some questions. And I think I've asked you this before, but we'll go over it again. Are you currently under the influence of any drugs, medication, or alcohol that would affect your understanding of these proceedings?
No.
Do you understand that you have the right to be represented by an attorney throughout these proceedings?
Yes.
Do you understand that if you cannot afford an attorney, that an attorney can be provided to you at no charge to you if you qualify financially for that service?
Yeah, we've already done that.
I know, but do you understand that?
Yeah.
And do you understand that I would appoint counsel to represent you if you wanted an attorney to represent you, provided you meet that financial eligibility requirement? Do you understand that?
Yes.
Do you have any legal training?
No.
How far have you got in school?
Some college?
Do you understand that the criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and presenting and representing your defense?
No, I don't understand that because I haven't seen evidence of it.
Because what?
I haven't seen evidence of that, especially through the attorney that I was provided that offered ineffective assistance of counsel.
Well, all I'm asking is, do you understand that the criminal, I'm not asking you to, about the specifics of the case. Generally, do you understand that criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and presenting your defense?
In theory, yes.
Do you understand that you will be held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications of an attorney?
No.
You don't understand that? I will explain it. You will be held to the same rules and laws as an attorney, even though you don't have the same training and qualifications. For example, the district attorney just discussed discovery. An attorney who is trained and qualified knows that they have to make a request to the district attorney to disclose the discovery. The district attorney doesn't just automatically provide it. Once they get that request, they will provide what they're required to provide under Rule 16 of the Colorado Rules of Criminal Procedure. The district attorney has said that you have not made that request yet. So that would be an example. So if you came back at trial and told me they never gave you discovery, then I would hold you to the same rules and laws as an attorney would be held to, which is that if you didn't request it, then that's on you, not them. So that's an example of you being held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications as an attorney. So do you understand that?
I don't, because my attorney, the ineffective assistance of counsel that was provided by the court, had already requested that discovery. And I keep filing the same discovery requests because they refuse to release it. Exculpatory evidence.
So I'm not, again, asking you, I just used an example from your case to illustrate the general idea. The general idea is, do you understand you will be held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications as an attorney?
Sure.
All right, court will find that decision is knowingly and voluntarily made. So in 25M426, what is your plea to obstructing a peace officer, guilty or, well, actually, I should probably have the people recite the last offer communicated to Mr. Sullivan on one or both of these cases if it's a global offer.
Yes, Your Honor. In 24M439, the last offer was to plead to original count 1, no proof of insurance with a $500 fine and 4 points against the DMV. In 25M426, the last offer was to plead guilty to original count 1, obstructing with 6 months of unsupervised probation and ISAE discovering better choices class within 5 months, 16 hours of UPS within 5 months, and to remain law-abiding. Both of those offers are now revoked.
Well, we'll get there in a minute. So in 24M439, if the plea of guilty is to count 1, does that, am I correct in inferring the offer contemplates dismissal of the remaining counts?
Yes, Your Honor, I apologize.
Mr. Sullivan, did you hear what the district attorney just communicated?
Yes.
If you enter a plea of not guilty, all of the, you will be communicating to the district attorney, you would not accept that offer. You'd be communicating, and the district attorney is free to withdraw it. And if they choose to withdraw it, they may choose not to put any new proposals on the table for a resolution of either case, which may leave the trial that I set as a result of your not guilty plea as being the only way to resolve the cases. Do you have any questions about that?
No.
So in 25M426, what is your plea, guilty or not guilty?
I do not consent to enter any plea on my behalf. I do not comprehend or understand how to enter a plea as there is no injured party in this matter, and no evidence of any contractual obligation requiring performance to follow the corporate state of Colorado statutes, codes, ordinances, and rules that are merely policies of the corporation acting as government under the color of law, outside the bounds of the constitutions of the United States and the state of Colorado.
All right, so it sounds like you're refusing to enter a plea, is that correct?
Yes, sir.
And the court will enter a not guilty plea on your behalf. On 24M439 to count 1, driving without insurance, count 2, obstructing a peace officer, count 3, driver's license refusal to display it, count 4, fictitious plate. What are your pleas, guilty or not guilty?
I do not consent to enter any plea on my behalf. I do not comprehend or understand how to enter a plea, as there is no injured party in this matter and no evidence of any contractual obligation requiring performance to follow the corporate state of Colorado statutes, codes, ordinances, and rules that are merely policies of the corporation acting as government under the color of law, outside the bounds of the Constitution of the United States and Colorado State.
So it's, am I also correct in inferring you are refusing to enter a plea in 24M439 as well?
Yes, sir.
Court will enter a not guilty plea on Mr. Sullivan's behalf. Are you requesting a trial to the court or a trial to a jury on these two cases?
I'm demanding a trial by jury.
All right.
And are you planning on scheduling those back-to-back, Judge? Is that my understanding?
I beg your pardon?
Are these trials scheduled back-to-back?
Right. So if one will go and the other one will get continued.
Okay.
And Mr. Sullivan, are you ready to proceed to trial?
No, I don't believe so. Well, maybe on the 439 case.
Yes,
I know that.
yes or no answer to know how to proceed next.
Well, I was prepared. I didn't know we were splitting them back up.
Beg pardon?
I didn't know that we were splitting them back up.
Why we're splitting them back up?
Well, they're scheduled for the same day for this trial next week.
Right. They wouldn't both go to trial at the same time. They would, one or the other would go.
Okay. Well, then, yeah, I can do 439.
All right.
And that 426, I'm still waiting for discovery and disclosure of witness names.
Then I will note that the deadline for resolution is February 23rd at 12:30 p.m. Will you be requesting the new reasonable doubt instruction?
Yes, sir.
The new reasonable doubt instruction reads as follows. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If you are firmly convinced of the defendant's guilt, then the prosecution has proven the crime charged beyond a reasonable doubt. But if you think there is a real possibility that the defendant is not guilty, then the prosecution has failed to prove the crime charged beyond a reasonable doubt. And a reasonable doubt can be based on the evidence presented or the lack of evidence presented. New reasonable doubt. Are you going to have an objection to me reading that reasonable doubt instruction to the jury?
Pardon me?
Yes.
I'm fine with that. That's fair enough.
People, how long are you asking for voir dire?
It's 10 minutes, Your Honor.
Mr. Sullivan, how long are you asking for voir dire?
For what?
Voir dire.
I don't know what that is. What's
It's the process where you ask the jury questions to find out ahead of the jury being selected whether or not the people who are called to serve as jurors can be fair and impartial.
Is that between individuals or in?
Mr. Sullivan, you may recall when I gave you an advisement that said that if you're choosing to represent yourself, you need to understand that you will be held to the same rules and laws as an attorney would, even though you don't have the same training and experience as an attorney. So I'm not planning, I'm really not able to coach you through this process. I'm expecting you to come to court already having this knowledge of what will be happening at a jury trial.
Well, all I can do is guess at this point.
Let me put it this way. We will not slow the trial moving forward because you are not knowing or understanding things you should know or understand ahead of time. For example, Voir dire will be 15 minutes in length, regardless of how long, once you have figured out what voir dire is, how long you want to use on voir dire. It'll be 15 minutes in length. How long are the people requesting for opening statements?
5 minutes, Your Honor.
Mr. Sullivan, is 5 minutes going to be long enough for you to make your opening statement?
Maybe go 10.
The court will allow 5 minutes for opening statement because what needs to be, what is stated during opening statement is a recitation of facts. It's not argument or commentary on the law. And 5 minutes should be adequate to cover that. People, how long are you asking for closing?
10 minutes, Your Honor.
And sir, how long do you think you need to close?
I imagine that'll work.
Beg your pardon?
I imagine, well, clearly you're just going to say 10 minutes, so I'm going to say 20 minutes. Because I'd rather have extra time, whether I need it or not,
Well, I will allow
than
15
getting cut
minutes.
short.
I will allow 15 minutes for closing because there are 4 counts. Those counts do not all rely on the same evidence. So there may need to be a little bit more argument regarding how the facts fit or don't fit with those elements. Will any witnesses need special accommodations, people?
No.
Are you planning on using the courtroom technology?
Yes, Your Honor.
Mr. Sullivan, were you planning on using your computer to publish exhibits to the jury?
To my knowledge, that's the only way to do it, is if I bring my own
I
equipment.
don't understand what you're saying.
To my knowledge, that's the only way to do it, is if I bring my own equipment, right?
Well, no, you can have paper copies and share them with the jury by having them look at paper. The reason why I'm asking, if you're planning on publishing with a computer, then you will be using the courtroom technology to accomplish that. And again, it's a situation where you need to be ready to have that going, because I'm not going to wait to troubleshoot issues. We won't be troubleshooting issues in front of the jury.
Okay.
I don't know if I can ask about exhibits, conferring on exhibits, because I don't have an exhibit list.
I haven't been provided any either.
All right, Your Honor. As I said, I will immediately after leaving here, I will provide that and also get some good contact information from Mr. Sullivan so he and I can confer so that we can make sure that there are no issues going into the trial.
All right. Do you have exhibits that you intend to admit?
Just body worn camera, Your Honor.
I'm sorry, I'm speaking to Mr. Sullivan.
Oh, yeah, I've got an exhibit list turned in.
Right, but the question is more directed. Well, you answered my question, so I'm going to ask the next question, which is, do you know how to admit exhibits?
Probably not. As far as getting them to the clerk, or?
No, getting them in front of a jury.
Oh, no.
Asking me whether or not I will allow the exhibits you have to be in front of a jury, to see, to allow the jury to see and consider the exhibits as evidence.
No, I don't.
Okay. Again, that's something you are expected to have ready. You are expected to have, you are expected to be ready to do. And so what I'm not going to do is coach you through the process. And what I'm not going to do is wait for you to figure out how to admit it in real time. I'm telling you this now so that you are not surprised when we get to the trial. I don't know if there's anything else I need to take up. This trial is second in priority, so if Mr. Bangs is ready to proceed to trial, this trial will be continued. If Mr. Bangs is not ready for trial for any reason, then this trial will proceed. With regard to 25M426, I granted the people's request to add count 2, speeding 20 to 24 miles over posted speed limit. Class A traffic infraction, count 3, failure to provide proof of insurance, a class 1 traffic misdemeanor. And count 4, displaying fictitious or altered license plates, a class 2 traffic misdemeanor. All also alleged to have occurred on April 7th, 2025. What is your plea to those 3 newish counts, guilty or not guilty?
I don't consent to enter a plea. I was never served with any of the documentation for that motion.
So the court would first note that it's your responsibility, sir, to make sure that we have current contact information. So the information that when we take an action on this case, you're notified about it.
Are you insinuating that my contact information has changed?
I granted this motion on November 12th. Did you receive a copy of my order?
Yeah, I did, and I objected to it, and
Then and did you get a copy of the motion before ahead of my order granting it?
no, I just got the order granting it. I didn't receive anything.
So do the people have current contact information for you?
It hasn't changed.
What?
It hasn't, my contact information hasn't changed. My mail continues to go to the same address. That is the only thing that I have noticed.
So people, it appears you have the correct email address, and I don't know if you've been emailing copies of what you've been filing, but you are not sending information to the correct mail address. You have it as Fort Collins. It's not Fort Collins, it's Loveland.
Understood, Your Honor. I'll make sure that we update that in our system. I do believe, though, that through e-filing, he should be getting automatic mail notifications.
What now?
Should he not be getting mail notifications through e-filing? No? Okay. I'll just double check to make sure that we have the correct address on file so we can ensure that that is getting sent to him. Also make sure that I just email him copies of everything that's been filed in the case thus far. And as I stated earlier, I'll get in touch. I'll speak with Mr. Sullivan right now to get some updated contact information so we can confer about everything regarding both of these cases.
Court enters a not guilty plea on Mr. Sullivan's behalf, and on counts 2 through 4 in 25M426. 25M426, the request to continue is granted. Anything else we would need to take up for Mr. Sullivan?
Just to ensure that we focus on the actual law as it stands and not some of the superfluous materials which have come up throughout the case.
I intend to keep a tight lid on this case may be about and what it may not be about, which, Mr. Sullivan, I think the best information you should take away from that answer is if I make a decision about an argument or a piece of evidence that you disagree with, you are free to object. You are not free to argue with me about it. If I sustain an objection to a piece of evidence or an argument that you make, you may not try again to get the same piece of evidence or argument in front of the jury. I shouldn't have to sustain an objection more than once to a particular piece of evidence or a particular argument. I'm expecting full cooperation with that, and if you believe I'm mistaken, you are free to object, and if I overrule your objection, your remedy is not to either keep arguing with me about it or to keep making the same objection over and over again. It is to wait to see the outcome of the trial, and if the outcome of the trial is a conviction, then you may appeal any error that you think I might have made. Do you have any questions about that?
No, I've made it clear that I don't feel like there is a fair trial involved. So I'm just here for the rigmarole so we can get to that.
We're ready, Your Honor.
Okay, we can call it.
Calling case 230-601-1701, the people of the state of Michigan versus Albert Hicks. The defendant is charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, domestic violence, aggravated second offense notice. Today's the date and time for an examination. Appearances, please.
Good morning, Your Honor. Madison Oro on behalf of the people, requesting permission under MCR 8.120P under the supervision of Attorney Shelley Gray.
Attorney Monica Sanford, P6. Attorney Monica Sanford, P62315 on behalf of Albert Hicks.
Today's the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, the people are ready to proceed.
How many witnesses for the people?
One witness, Your Honor.
And Mr. Hicks, tell us your name for the record, sir.
Say your name.
Albert Heimer Hicks Jr.
All right, call your witness.
The people call Ms. Kimberly Hubbard to the stand.
Give your name and spelling to the court reporter. Okay, stand closer to the podium so I can see you and raise your right hand. Back towards the podium where the prosecutor is. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat in the witness box next to the bench. Keep your voice up nice and loud and speak into that microphone that'll be to your left. You may begin when you're ready.
Thank you, Your Honor. Can you please state your name for the record? Kimberly Hubbard. Thank you. Ms. Hubbard, I want to draw your attention to November 22nd, 2023. Where were you on that day?
At my house, 15212 Stratmore Street.
Okay.
Detroit.
So you just said that's in Detroit. That's in the county of Wayne?
Yes.
Thank you. And did something happen on that day that brings you into court today?
Yes.
What happened on that day?
I was assaulted by Mr. Hicks.
Okay. So you stated you were assaulted by Mr. Hicks. Is that Albert Hicks?
Yes.
Okay. And how do you know that person?
He was my partner, and he is the father of my children.
Okay. How long were you guys partners for?
Around 14 years.
And do you see that individual in the courtroom today?
Yes, I do.
Can you please point to him and identify a piece of clothing that he's wearing?
Yes, he has on a black vest.
Thank you. Your Honor, please let the record reflect that the defendant has been identified.
Noted.
So going back to this assault, as you stated, can you just explain to the court in a little bit more detail what occurred?
Well, I worked a 12-hour shift that day. I worked for a before and after school program. So I worked from 6:30 a.m. to 6:30 p.m. I get off of work. I get in the car with Mr. Hicks. He drives me to and from work. I get into the car. I can tell that he's a little upset. So we're talking, and he begins to argue about some things from the past, jobs that he was owed for in the past. So that's how the argument started. I didn't really feed into the argument. I wasn't trying to respond to the argument. It was just kind of, let's just get home.
Okay.
So we ended up pulling into.
I'm gonna stop you right there, I'm sorry. I just want to, ask you a few questions about what you just stated. Okay, so just to clarify, Mr. Hicks picks you up, takes you and picks you up from work.
Correct.
Okay, and on this date, November 22nd, he was picking you up from work?
Correct.
Perfect, and you got into the vehicle with him, and, you stated there was an argument, right?
Yes.
Okay, and so you were going into a little bit detail, sorry, about, what the argument was pertaining to, and so can you state that again? What the argument
It was about a prior, job that he had done. He just home improvement. It was a prior job that he had done that he wasn't, properly compensated for.
Okay.
That he said he wasn't properly compensated for, which I had nothing to do with.
Okay, so after he is, expressing these things to you about these, different jobs that he hasn't been properly compensated for, what happened next?
He just kept yelling, oh, I'm gonna get my money. The job he is referring to, he had done for my current employer. So he felt like I had something to do with that, but I had absolutely nothing to do with that. So I just wouldn't feed into it because that has nothing to do with it.
I understand. So, earlier in your testimony, you stated, that Mr. Hicks assaulted you. So at what point did this, argument between the two of you turn physical?
Once we got to the residence, which is the Strathmore residence, which I spoke of, we pulled up into the driveway. He got out of the car and he went into the home. I did not go into the house because I did not feel like he was calm enough for us to have a conversation or for us to be in the same house.
Okay, so sorry, I'm so sorry. Just to clarify, so you guys are currently on the drive home while this verbal
With the verbal.
Perfect. And so you get to the home, and Mr. Hicks parks the vehicle, goes inside, and you stay in the car.
Yes.
Okay, great. And I'm sorry, can you continue back?
I stay in the vehicle. I'm watching movies on my phone. My daughter is sitting in the car with me. She's going back and forth into the house. I asked her to bring me my throw blanket out to the car. I was going to stay in the car. Mr. Hicks continued to come in and out of the house to pursue the argument, but I did not feed into that argument. When he realized I wasn't going to feed into the argument, the last time he walked out, he asked for my keys, and I told him he was not getting my keys.
Just to clarify, Ms. Hubbard, the vehicle that you guys, the keys that you're referring to, they belong to the vehicle that you
No.
Oh, okay, just wanted to clarify.
House keys.
Okay, thank you.
House keys. He wanted my house keys, and I told him no. And that's when he pursued to bang on the window. And I would not open my door. I kept my door locked, but he hadn't set the keys to the vehicle. So he unlocked the vehicle and pursued to get in the back seats of that vehicle. And first they started off as verbal, and then when he wasn't getting the responses that he wanted, they turned into a physical attack.
Okay, Ms. Hubbard, when you say physical, was there, when you say physical, can you just explain to the court, what it is, that you mean exactly?
He tried to put pressure on my neck with his wrist. So when he did that, I struggled to breathe. And at some point, I'm not sure when, I was hit in my left eye, and had to receive liquid stitches in my left eye. I'm not sure when that occurred because it was a bunch of me trying to get him off of me.
Commotion, I understand. Okay, so just for the record, you're pointing to your kind of like the flat surface of your wrist, correct?
Yes.
Okay, so kind of where the wrist meets the hand. Okay, thank you. And when you say that he was putting his wrist on your, you put your wrist on your neck, correct? Okay. In that moment, did you lose consciousness or anything?
I don't believe I lost consciousness. I just know I struggled to breathe and push him push him off.
Okay, and, sorry, just to back up a little bit, when he was using his wrist, it was just one of his wrists, right?
Yes.
Not both?
Yes.
Okay. And, could you feel like you could breathe in that moment?
It was struggle, it was hard. It was like, it was restricted.
Okay, so your breathing was restricted. What would you say your vision was like at that moment?
My vision was a little blurry.
Okay.
Everything was happening so fast.
Yeah, I understand that. So what was what was the defendant's demeanor like while all of this was happening?
He was very angry, very.
And was he saying anything while he was
He did threaten to take violence.
And based on that, Ms. Hubbard, and everything else that you testified to today, how would you describe that you were feeling in that moment?
Afraid. I fear for my life even today.
Okay, just one moment. Okay, no further questions, Your Honor.
Suzanne?
Ms. Hubbard, you indicated that, Mr. Hicks had picked you up from work, is that correct?
Yes,
And, he was driving you in the vehicle back to the residence where both of you resided at that time, is that correct?
that's right.
And as he was driving back, he was expressing his concern about not being paid appropriately for services rendered for your employer, is that correct?
Yes, that's right.
And so you indicated that, you did not engage, you didn't have anything to say in response, is that correct?
That's right.
And then you indicated that at some point you arrived at the residence, is that correct?
That's correct.
And Mr. Hicks went inside, but you remained in the vehicle, is that correct?
That is correct.
And at some point, your daughter noticed that you were in the vehicle, so your daughter came and got in the vehicle with you.
That is correct.
And at some point, you asked your daughter to go in and get your blanket or something of that nature, is that correct?
That is correct.
And so, at some point, you're indicating that Mr. Hicks came back out to the vehicle and was standing at the window yelling at you.
That is correct.
And he asked for your house keys.
That is correct.
But he had entered the house, right? So he had keys to enter the house, correct?
That's correct.
All right. And so your response to his request for the house keys was no, is that?
That is correct.
Okay. And so at some point, he unlocked the vehicle
That is correct.
and he got in the back seat.
That is correct.
Now, what type of vehicle is this?
Town and country van.
Okay. So this is a van, and is it fair to say that you have two individual seats in the front?
Yes,
And are there two individual seats in the back, or is it a bench seat
it's two individual seats in the middle.
in the middle? Okay. And so where was he located?
In the back seat on the driver's side.
So he's in the back seat on the driver's side, and you're in the front seat on the passenger side, is that
That
correct?
is correct.
Okay. And so you indicated that at some point he takes the back of his wrist, if I remember how you wrist, the lower part of his wrist going into where his upper part of his arm is. And he reaches over from the back seat with his back side of his wrist, and he presses on your throat.
Correct.
And from the back seat, from the driver's side, he reaches over to the passenger
He
side.
put his body in between the two front seats.
And so he puts his hand on your throat, is that correct?
That is correct. His wrist.
And his wrist, thank you for correcting me, his wrist on your throat. And at some point, you struggle to breathe, but you never lose consciousness, is that correct?
That is correct.
Now, while he's putting his wrist on your throat, at that point, is he saying anything?
He's saying that I should kill you.
Okay. And so, then you indicated that at some point, somehow, you ended up with, cut to or laceration to your eye, is that correct?
Yes.
but you don't recall exactly what happened or how that occurred. Is that fair to say?
No, I'm not sure how that occurred.
Okay.
It occurred within that moment, but I'm not sure how.
Okay. And so at some point, you get this laceration to your eye, and at some point the police are called and the police arrive. Is that fair to say?
That is correct.
Okay, and Mr. Hicks leaves the vehicle. Is that fair to say?
Once the police arrive, yes.
Okay, but prior to the police arriving, after you have an incident with your his wrist on your throat, did that happen before or after the laceration to your eye?
That happened before the laceration to my eye.
Okay, so the throat was first, the laceration was second.
That is correct.
And you're confident all of that occurred as a result of Mr. Hicks?
That is correct.
No further questions.
Any redirect?
Just super briefly, Your Honor. Ms. Hubbard, I just want to ask you really quickly, did you receive any treatments for your injuries?
Yes, I went to San Andres Hospital.
Okay, and that was directly after this incident?
Yes, it was.
Okay, no further questions.
Thank you, ma'am. You may step down. Any other witnesses on behalf of the people?
No other witnesses on behalf of the people, Your Honor.
Any witnesses on behalf of the defendant?
No, Your Honor.
People?
Your Honor, at this time we reserve argument and ask that I over as charged.
Counsel?
Your Honor, I understand that there are two counts to this charge. One is an assault with intent to do great bodily harm, less than murder or by strangulation. The other is a domestic violence aggravated second offense notice. And I would indicate that at this point, I would argue that the prosecution has not met their burden to establish that there has been an assault with intent to do great bodily harm, less than murder, nor by strangulation or a domestic violence aggravated. Ms. Hubbard's testimony was he reached from the back seat, put his wrist on her throat. It's hard to see how somebody reaching from the back seat would be able to put their wrist on somebody's throat. Their wrist only, not that his hand grabbed around her throat, not that he put any grip on her throat, but just merely his wrist was on her throat and caused her to struggle to breathe. I don't feel that the testimony rendered by Ms. Hubbard was credible, and I'd ask that case be dismissed.
People?
Yes, Your Honor. So gripping of the neck is not necessarily an element of the statute of strangulation. But what does need to be met in the strangulation to meet those elements, just regard that someone was in fact strangled and that their breathing was somehow affected, whether it was restricted, whether they lost consciousness. And the complainant in this case did state that she, her breathing was restricted, that she did have difficulty breathing. And I think that given, certain size differences as well, it's not necessarily super shocking that someone from the back seat could apply, pressure onto somebody else. But with that being said, we don't necessarily need to prove any sort of full hand grip. We just have to prove, that someone essentially, that someone was strangled or choked and that their breathing was in some way affected by that. So with that being said, we do believe that we have met our burden.
Even more so than that, what's important here is what the defendant's alleged intent is or was at the time that he put his wrist or his hands around the complaining witness's throat. She also indicated that he said when he did that, that I should kill you. She said that her breathing was restricted as a result, and I didn't find anything inherently incredible about the witness's testimony. As such, the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint and warrant. The court finds those charges were committed in the city of Detroit, and the court finds probable cause to believe this defendant committed them. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information, date, and time will be January 2nd, 2024 at 9:00 a.m. Bond will be continued.
Thank you, Your Honor. Judges, two things I want to address before. First, I didn't hear the date of the arraignment. What date did you say, Judge?
January 2nd, 2024.
Okay. Your Honor, it is my understanding that this was Mr. Hicks' home in which this alleged offense occurred. It is my understanding that the alleged victim is no longer at the home. She has left the home. I believe when we had the PCC, she acknowledged that she had left the home. I'm asking that my client be able to return to his home at this time.
And Your Honor, Your Honor, if that's true, the people have no objection to that. However, APA Shelley Drain did just go ask the complaining witness if that is in fact true.
Okay, give us a second. We'll verify that.
Okay, and the other issue is when I was at the PCC, I asked for my client to be able to be go to work Monday through the weekend, actually 6 to 6. The court agreed to 6 to 5 Monday through Friday. That prohibits him from working on Saturdays and Sundays while he's doing his home repair work. He's asking to be able to do home repair work on the weekend as well.
Okay, Judge, we have an update. The complaining witness in this case, did state that all of her belongings are in this home. So if she could just have 72 hours to just retrieve her mail and some of, her belongings, then yes, we would have no objection to the defendant staying there for 50 days.
Counsel, you okay with that?
72 hours is fair for her to get her things.
Okay. Send over a proposed order to that effect. As it relates to him working on the weekends, he's doing what? Home improvement.
Yeah, he has his own business, Your Honor. I had addressed this at the probable cause conference, and you had given him 6 a.m. to 5 p.m. Monday through Friday, but sometimes he's doing home repair on the weekends as well when he's trying to finish up a job. And so he's not able to go on the weekends because you only gave him Monday through Friday.
People?
Your Honor, people don't have any objection if he's trying to get to work.
All right. Give me an order to that effect as well.
Okay, thank you, Your Honor. I'll send it over.
All right, thank you.
If I don't see you anymore, enjoy your holidays.
Thank you. Same to you.
Well, there it is, guys. We have come to the end of our video. And as you can see, definitely a very serious situation. If you are familiar with Albert Hicks, it kind of makes sense now. Some of the aggression that he has, some of the aggression that he had towards Judge Perkins, where Judge Perkins put him in check. If you haven't seen that video, definitely go and check it out. But Judge Perkins had to put him in check because he kind of threatened Judge Perkins while he was on Zoom court, and Judge Perkins really wasn't having it. But this is a serious situation. Hopefully this situation gets resolved. I tried to follow up on this case, but unfortunately the court that it was transferred over to, they don't allow videos on the internet. But what I did see was that there was a motion for his lawyer to be removed from the case. So it looks like even though he started out with a lawyer, he definitely turned, put his sovereign citizen head on. And also I saw where there was a competency hearing ordered as well. So this case is still going on. I mean, I will update you on it just to let you know what happened once I get some more news. But currently, there's a competency hearing that is supposed to go forth on Albert Hicks. And once they do that, I guess the case will move on and they'll figure out what's going to happen with this situation. But we pray for this young lady. Hopefully, we know that there's two sides to every story, but it sounds like this got pretty physical and pretty brutal. And we pray that Albert Hicks, get some help for, whatever he's dealing with, whatever anger issues, whatever it is that he's dealing with. I mean, even him sitting at the table, just sitting there listening to her, he didn't look too happy. For whatever reason, he kept his hands on the table. I don't know what that's about. I don't know if that's something his lawyer told him to do, but all that was a little weird. But maybe that's a strategy that defense attorneys tell, people that's involved in domestic violence. I don't really know. But nonetheless, I appreciate you guys sitting in. Wasn't our normal Sovereign Citizen video, but I thought you guys would be interested in this because of who it was in this particular proceeding. So with that being said, guys, thank you once again for joining Sovereign Citizens Hall of Fame. And with that being said, God bless you, and court is adjourned.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.